Magandang araw. This is our video discussion of module number 15 for BAM 026. Our lesson title is still about extinguishment of obligation. This time around, we are going to talk about compensation. So our lesson objectives are as follows. At the end of this module, you can define what is compensation, identify the kinds of compensation, and state the effect of compensation to the guarantor. I know that at the back of your mind, the first understanding that you have kapag narinig yung word na compensation ay para bang yun yung sweldo. But however, in obligations and contracts, law on obligations and contracts, compensation has a different meaning. All right. So before going to the discussion about compensation, let's talk about the productivity tip first. Productivity tip, the starting point of goal achievement in every area is desire. He who has a why to live can bear almost any how. Start with answering why there is a need for you to accomplish this, and you will appreciate the fact that hard work is always a part of all successful journey. Right? So kapag kasi alam mo yung dahilan kung ba't ginagawa mo isang bagay, mas madali para sa iyo na madiskubre yung mga pamamaraan at minsan handa ka na rin gawin lahat ng paraan para ma-achieve yun. Alright, so here is our lesson preview. Extinguishment is the end life of an obligation. So usually it happens when the debtor finally pays its obligation to the creditor. However, you know for a fact that payment or performance is just one of the modes of extinguishment of an obligation. Complexities in the human transactions paved the way to different modes of extinguishment of obligation. So we have already discussed in our previous modules the following modes. We have already discussed payment and performance, loss of the paying due, remission or condonation of debts, as well as confusion or merger of rights. So anim yan, this time around, we are going to talk about compensation. Tapos sa next module, novation naman. Okay, so of course, you need to pause this for a while and answer the what I know chart. Welcome back. So what is compensation? According to Article 1278, compensation shall take place when two persons in their own right are creditors and debtors of each other. So tignan natin itong usapan ng dalawang mag-sis na to. Sabi ng isa, can you still remember you owe me 5,000 which is due today? Anong sabi naman ng isa? Yes, I can still remember that, my friend. But you also owe me 5,000 which is also due today. Anong sabi ng aso? Sabi ng aso, you don't need to pay each other. Did you know that there is this thing called compensation? Arf. Okay, anyway. Point lang dito, kung may utang si A kay B at ganun din naman si B kay A, is there really a need for them to pay each other? Hindi ba po pwedeng compensation na lang? Ayan. So, from that particular example, I know that you have now a hint of on what compensation is really all about. Now, let's move on. Compensation. Ito tayo ha. It is the extinguishment to the concurrent amount of the debts of two persons who, in their own right, are debtors and creditors of each other. So it involves the simultaneous balancing of the obligations in order to extinguish them to the extent in which the amount of one is covered by that of the other. So sa madaling salita, from these particular words of Manresa, we can say that compensation can also be partial compensation. Nagkataon lang na si A dito ay may utang na 5,000 at si B may utang din na 5,000. So, super tabla lang silang dalawa. When compensation happens, talagang 0-0 na yung utang nila sa isa't isa. However, just in case lang halimbawa na si A may utang na 5,000 at si B naman 2,000, there is a need still for B on the part of B to pay the remaining amount. So pag-usapan nga natin itong kinds of compensation, kagaya na sabi ko sa inyo, as to effect or extent, meron tayong total or partial. But as to cause of origin, meron tayong legal and voluntary. So when you say legal, it takes place by operation of law or by order from a court. Pero pag voluntary, it takes place by the agreement of the parties. Pag sinabi natin voluntary, please know that it is also what is known as conventional. Okay. So requisite of legal compensation. So in order that compensation may be proper, it is necessary that the parties are principal creditors and principal debtors of each other. Of course, both debts consists in a sum of money or of consumable things of the same kind and quality. So dapat daw pareho na amount, parehong pera o kaya naman consumable. Okay. So hindi naman kinakailangan na uniform yung amount. Sabi lang dito, it must be consist in a sum of money, but not necessarily same amount of money. Ayan. Next, both two debts be due. Dapat pareho payable na or due date na. Both are liquidated and demandable. When we say liquidated and demandable, it must be payable at the time na it must be demandable and payable at the time kung saan dapat na sila na magkaroon ng compensation. Okay. Next is there is no retention or controversy commenced by third person and communicated in due time to the debtor. So ano ba ibig sabihin nun? Minsan kasi merong mga third party or third persons na tinatawag kung saan may hinahabol sila na pera from a particular person. So pag nagkataon na may controversy or issue doon sa isang tao, minsan yung compensation hindi pwede na isakatuparan. So these are the requisites of legal compensation. Pag-usapan naman natin yung effect of compensation to the guarantor. So the guarantor has given the right to set up compensation, and the extinguishment of the principal obligation as a consequence of compensation carries with it the accessory obligations such as guarantee. Ano ba yung guarantee? Kailan ba nagkakaroon ng guarantor? Gaya na sinabi ko last module, ang guarantor ay yun yung isang tao saan ginagarantiyahan niya na kapag hindi nagbayad si debtor, siya yung pwedeng singilin at siya yung magbabayad ng obligation. Ngayon, yung contract of guarantee ay isang accessory contract. Pag sinabi natin accessory contract, nakadepend ang existence nito sa isang principal contract. So, in case na perang usapan, contract of loan, yun yung principal na obligation, tapos merong guarantee, so yun naman yung accessory obligation or accessory contract. So if that's the case, kapag halimbawa, nagkaroon ng compensation dun sa guarantor, pag nagkaroon ng compensation sa principal amount, na-extinguish na rin yung guarantee. Why? Because, sabi ko nga sa inyo, yung existence ng guarantee o ng accessory obligation ay nakadepende doon sa principal obligation. So logic dictates kapag na-extinguish na yung principal obligation, dapat yung accessory obligation ay ma-extinguish na rin. So pag-usapan natin yung example para mas malinaw. Halimbawa, X owes Y 2,000 with G as guarantor. Ito yun na. Ito tayo. So ngayon, again, si X may utang kay Y na 2,000. Tapos si G yung nag-guarantor. Ngayon, si Y may utang din na 2,000 kay X. So, the obligation of guarantee is extinguished by compensation. Ina-assume na lang siguro dito na same na lang due date, no? That all requisites are present. Yan. So, dito, because of the compensation between X and Y, si G, yung kanyang obligation of guarantee is extinguished by compensation. But, if compensation is only partial and X cannot pay the balance, G will be liable for the balance. So, kung si X may utang kay Y, halimbawa, na 2,000 at si Y may utang lang kay X na 1,000, pag nagkaroon sila ng compensation, partial na. Okay. So, di ba dapat babayaran pa ni X si Y ng 1,000? However, just in case na hindi na talaga siya makabayad, si G, hindi pa rin na-extinguish yung kanyang obligation. Why? Kasi yung principal obligation, di ba? Andun pa. Meron pang dapat bayaran na 1,000. Tignan natin itong comics. Ito na naman itong aso. Pangatlong, ano na yun, pangatlong sighting na natin sa kanya. Sabi rito ng lalaki, girlie owes me 5,000. I would like to assign the credit to you. The debt was due yesterday. Are you interested? Sabi naman itong si girlie. Yes, Jake, I am interested to be the new creditor of girlie. Sabi ng aso. But Jake also owes girlie 5,000 due yesterday. The debt is extinguished by compensation yesterday. So gustong maghumiyaw ng aso. Kasi, alam nyo, yung accounts receivable, pwede yung i-assign. Pwede mo yung ibenta. So, kung sa accounting sana nadaanan nyo na, which I am not aware of, kapag yung accounts receivable mo o yung mga pautang mo, kung pwede mo yung ibenta sa iba, pwede mo yung i-assign sa iba. Okay, paano ma'am yung nangyayari na? May tinatawag tayong factoring. Sana, kung may accounting kayo, sana matouch nyo na yung topic na yun para mas maintindihan. But my point really is, yung kasi yan, parang, kumbaga, kung nagmamadali ka na makasingil, pero yung due date matagal pa ng accounts receivable mo at kailangan mo ng pera ngayon, one thing that you can do really is to sell your accounts receivable to another person. Yun nga yung ginagawa ni Jake na to, binebenta niya yung pautang niya kay girlie na para bang ina-assign na niya yun sa iba. Kaya lang ang problema dito, ang hindi alam nitong si girlie, may utang din ang hindi alam nitong, ang hindi alam nitong walang sinabing pangalan, ano? Ang hindi sinabi, hindi nga sinabi pangalan. Ang hindi alam nitong babae na pinagbebentahan ay may utang din si Jake kay girlie na same amount. So kung nagkataon, ano to talaga, extinguish na talaga yung obligation because of compensation. So pag-usapan natin tong assignment. When compensation has taken place before assignment. So sabi rito, assignment of credit is where the creditor assigned the debt to a third person who becomes the new creditor. However, where compensation has taken place before the assignment, it is clear that the obligation is already extinguished prior to the assignment. And if this is the case, the remedy of the assignee is against the assignee. Sa madaling salita, maghahabol tong si ate kay Jake kung sakaling nagkatuluyan sila sa transaction na pumayag siya na yung maging new creditor ni girlie. Ma'am, paano ba kumikita yung mga bumibili ng accounts receivable? So tulad in this particular scenario, ang accounts receivable niya 5,000. Hindi ito bibili ni ate girl ng 5,000 din. Pwede na bilhin niya ng 4,500, basta mas mababa. Nang sa ganon, kikita rin naman siya sa pamamagitan ng pag nakasigil na siya, makukuha niya yung full amount. Next. Instances where legal compensation is not allowed by law. Compensation shall not be proper when one of the debts arises from a depositor or from the obligations of a depository or of a bailee in comodato. So, hindi raw allowed ang legal compensation. Next. Comodatum is a gratuitous contract whereby one of the parties delivers to another something not consumable so that the latter may use the same for a certain time and return it. So, example, A borrowed the cell phone of B. B cannot refuse to return the cell phone on the ground of compensation. This is because compensation cannot take place when on the debts arises from a comodatum. So, pansinin nyo, dito, si A, hiniram niya yung cellphone ni B. Ngayon, si B, may utang kay, si A, okay, mali itong example. Dapat, A cannot refuse to return kasi si A yung nanghiram. Ulit, si A, hiniram niya yung cellphone ni B. Ngayon, si A, hindi niya po pwede na hindi isoli yung cellphone na hiniram niya kay B. Kung halimbawa na may utang man si B. So, bago kayo maguluhan, kasi mali yung example, dapat ito si A ito. A. Ayan, ito. Ito. Si A nanghiram ng cellphone kay B. Ngayon, pagpalagay natin na si B may utang kay A. Tapos hindi niya po pwedeng sabihin na, oh, mag-compensation na lang tayo, total may utang ka naman sa akin, hindi ko susoli yung cellphone mo. Bawal yon. Bakit? Una sa lahat, dapat, di ba, sa requisites, kanina pinag-usapan natin, dapat dun sana pareho na pera yung pinag-uusapan. O kaya naman, yung thing ay pareho ng nature. So, balikan natin ha. Tingnan nyo to. Ito. Requisites. Okay, both debts consist of sum of money or of consumable things of the same kind and quality. So, cellphone sa cellphone, mga ganyan. Pwede yun. Eh, ito kasi pera sa cellphone. Di pwede. Isa pa, comodatum yung isa, iba yung kontrata. Okay? So, magkaiba ng nature. Next, neither can compensation be set up against a creditor who has a claim for support due by gratuitous title without prejudice to the provisions of paragraph 2 of Article 301. So, support comprises everything that is indispensable for sustenance, dwelling, clothing, medical attendance, education, and transportation, and in keeping with the financial capacity of the family. For example, si B is father of Zay. Zay is entitled for support under the law. If Zay owes B 2,000, B cannot compensate his obligation to support Zay by what Zay owes him. Okay. Pwede natin mag-ama to ha. Si B, yung tatay ni Zay. Ngayon, syempre si Zay bilang anak, may karapatan siya sa support for as long as hindi pa siya nakakatungtong ng legal age. Ngayon, for some reason, may utang si Zay dun sa tatay niya na 2,000. Hindi po pwedeng sabihin ni Pina, o hindi mo na kita bibigyan ng suporta kasi may utang ka pa sa akin. So, hindi niya po pwedeng sabihin nun. Okay, next. Neither shall there be compensation if one of the debts consists in civil liability arising from a penal offense. So, if one of the debts consists in civil liability arising from criminal offense, compensation would be improper and inadvisable because the satisfaction of such obligation is imperative. The provision pertains only to the accused but not to the victim of the crime. Pag-usapan natin itong example para mas maintindihan natin. So, halimbawa, si A, may utang kay B na 50,000. Ngayon, si B, ninakaw niya yung laptop ni A na worth na 50,000. Sasabihin, pwede bang sabihin ni B na, ayaw mo na, nananakaw ko yung laptop mo. Total, may utang ka na sa 50,000, quits na tayo. Pwede ba yun? So, the answer is no. Bakit? Because in this particular case, the civil liability arising from a penal offense cannot be subject to compensation. So, sana naintindihan nyo yung topic natin na compensation. Please answer the entire modules and see you all in the next discussion.